Hello, my name is Ian Scott, and I'm the founder of Scott Legal. We are here today to talk about the E-2 visa and moving from an E-2 visa to a green card, and we're going to look at the different ways to do that. The E-2 visa in particular is something that is near and dear to us, as the firm was founded on an E-2 visa, and I am on an E-2 visa myself. And we've helped a number of different applicants move from an E-2 visa to a green card. And, in each of these different categories that we're going to talk about, we have assisted applicants with that. A few housekeeping items: if you do have questions during the webinar, please feel free to add the questions to either the question and answer box or the chat box. We will get to all questions before we finish, and we do save time at the end for questions. So even though we may not answer them right as you present them, we will definitely get to them. In terms of after the webinar, a few things that we will send to you. This webinar is being recorded, and we will send you the recording, and we will also send you guides. We have E-2 visa guide, we have a national interest waiver visa guide, and an extraordinary ability visa guide. So really all of the different categories that we're going to talk about, the green cards that you possibly could move to, and the E-2 visa, we have guides for them, and we are going to send you a link where you can download those guides for free. And then finally, we do encourage you to subscribe to our YouTube channel. The webinars are, as I said, recorded. They are slightly edited and then put on the YouTube channel, along with a number of other videos on a number of different immigration topics. Now, for each of the areas that we're going to talk about today, we do have separate complete webinars on all of them, including the E-2 visa. So we do encourage you as well to sign up for a future webinar or go on our YouTube channel and take a look at one of the older webinars on a particular topic, because, for example, when we talk about the national interest waiver, the green card category, we do have hour-long webinars just on that particular green card. So definitely we are going to touch base and give a flavor today, but to the extent that you want more detail, it would be it would be good to sign up and look at one of those webinars. So without further ado, we will get started. So the first thing that I wanted to talk about is really just how the green card system works in the US, because it is very different from the way that it works in a lot of other countries. In a lot of other countries, they have a system which might be a points-based system where an individual will get points for certain things. For example, speaking the language, their education, their age, a number of different factors that the government finds advantageous. And once they get a certain number of points, then that particular individual is eligible for some type of permanent residency. And that's what a green card is. It's a permanent resident card. Now, the system in the US, though, unfortunately, and I say unfortunately because I think those systems definitely have some advantages, the system in the US works quite differently, because in the US, there are green card, they're just a list of green card categories. And then if you're eligible for them, you can apply. And unfortunately, things like the time that you were in the United States, your previous visa, which visa that you're in right now, unfortunately, that does not impact whether or not you're going to be eligible for a green card. But instead, you just, there is just a list of categories, and I'm going to run through those categories. And if you're eligible for them, let's say that you're in the United States on an E-2 or another type of visa, that if you're eligible for them, then you can apply, you can apply for the actual green card by meeting that criteria. So for example, if you marry a U.S. citizen, then you're on an E-2 visa, you can apply for an E-2 visa because you meet the category or the criteria for that particular category. And as I said, we're going to talk about each of those. So with that, the question often comes up of whether an E-2 visa leads to a green card. And the clear answer to that is no. And really, it's a bit of an interesting question, because there aren't any non-immigrant visas, so E-2, L1, H-1B, they're all temporary. When I say non-immigrant, I mean temporary visas, and none of them lead to a green card. Instead, what happens is that if you are on one of those visas and then you want to apply for a green card, you certainly can if you're eligible. The other thing I did forget to mention was that there is a PowerPoint presentation associated with this this webinar. I'm not broadcasting it on the screen. I'm talking about everything that's in the presentation, but you will actually get a copy of the PowerPoint when the presentation is over. So that's one thing that will be sent to you. Now, so in terms of what are these categories that I was just talking about? So the categories are broken up into really two main categories. One is family-based green cards, and the other is employment-based green cards. Now, for family-based green cards, they're further subdivided into what's called the immediate relative category. And the immediate relative category is not necessarily what you would first think of an immediate relative. So, for example, they don't consider a sibling an immediate relative, but immediate relatives are limited to children over 21 sponsoring a parent. They're just defined by their children over 21 sponsoring a parent, and U.S. citizen marrying someone, right? So those are kind of the immediate relative categories, examples of the immediate relative categories. And those have the benefit that the green card is always current. And we're going to talk about what that means in a little bit. But just say that just suffice it to say that it's quite advantageous to be able to apply under that category, and because there's a push for family unification, and the idea is that this particular category assists with that. The second category within the family-based area is the preference-based category. And that would be, for example, if a U.S. citizen wanted to sponsor their sibling. So that's an example of the preference-based categories. Now, the problem with the preference-based categories is that in most cases, the green card is not current. And, probably as good a time as any to talk about what that means. So with all of these, whether the family-based or employment-based green cards, the government, through congressional law, the government can only issue a certain number of green cards, broken down by country as well. But just for the purposes of this, just to make it easier, it can only issue a certain number of green cards per year. So once they meet that cap, then people start to go on a waiting list, right? So that waiting list for some categories can be quite long. So for example, for U.S. citizens sponsoring a sibling, the waiting list can exceed 14 or 15 years before the category becomes current. And there are other categories that are definitely faster. And I believe there's one category which is current, like for example, a green card holder sponsoring their spouse that happens to be current. But if the category isn't current and the green card isn't available, then the applicant has to wait until the category is available. And that's similar to, or really the same as the employment-based categories. As you go through the employment-based categories, again, Congress has allocated a certain number of visas or green cards by country. And once they have been used up, then people go on waiting lists. So some categories, like for example, EB3, which we'll talk about in a second, that is oversubscribed in certain countries. So in certain countries, there'd be a wait. So then we talked about family-based green cards. We talked about the wait related to green cards that aren't current. And so now we're moving into the employment-based green cards, and they're broken down into 5 areas, which are EB1 through EB5. And a lot of these we're going to talk about as we go through the presentation. So I think we'll leave it at that for now, but EB1 through EB5 are the employment-based green card categories that that are possible. So then with that, we talked a little bit about family-based green cards, but let's talk about them specifically with respect to E-2 visas. And so now we have a number of clients who come to the US, they're single, and then they meet their significant other in the US, and that person happens to be a US citizen. And that is a great way to adjust status or to get a green card at the consulate. And they do that. And the one good thing about this, again, as I said, the green card category is always current, but also another good thing is that when you marry a U.S. citizen and you have the green card for 3 years, you're eligible to apply for citizenship in 3 years, as opposed to everyone else who is only eligible after 5 years. So that's something to consider. You can become a citizen and have the right to vote a lot earlier than anyone else. In terms of the preference-based categories, we do have some individuals on E2 that move to the preference-based categories as well, but certainly not as many, because almost all of the preference-based family categories are backlogged. And so, we have some situations where someone might apply for an E2 and they have, let's say, a child over 21 that applies for an E2, but they have a parent in the US that's a US citizen that has sponsored them for a green card. So there might be a 5 to 7 year wait, but in that process, they may have applied for a green card. But it's just less common, I think, than certainly the immediate relative category or the other ways that people move to a green card. So one thing to keep in mind in terms of, and this particular process relates to all of the categories that we're going to talk about. Whenever you're applying for a green card, it's a two-step process. So the first part of the process is going to be proving that you meet the objective standard related to what you're applying for. So if you are applying for a green card based on marrying a US citizen, you're proving that it's a bona fide marriage, that you're actually married to a US citizen, that the marriage was legitimate and all that. If you're applying for a work-based green card, you're proving that you meet the qualifications, et cetera. So that is always going to be the first part of a green card. It's going to be different depending on which green card you're applying for, but that's always going to be the first part. So the second part is going to be I'd almost call it more procedural. So the second part has to do with the government really, and everyone goes through the same process with respect to the second part, regardless of which green card category you're applying under. But the second part really is getting at, is there anything about you that makes you inadmissible? Do you have criminal history? Do you have particular contagious illness that makes you inadmissible? Do you have psychiatric issues that might make you inadmissible? So the second part of the process is really looking at that, and the second part of the process can really be done in two ways. So that's either you're in the United States and you do what's called an adjustment of status, and when you do the adjustment of status, you file an I-485 petition, or you can do something that's called consular processing. So that's really saying that I plan on getting the green card at the consulate rather than getting the green card, in the US. So the person doesn't necessarily have to be in the US, or the person can be in the US and decide that they want to do consular processing, and there's often good reasons why that actually happens. So that is really the family-based process and the general process of how one moves to a green card. Now let's go to the first kind of employment-based category that we do sometimes see people move from E2 to a green card. The first one is called EB1A under the extraordinary ability category. So now what this category is, it's really saying that the individual has risen to the top of their field, and the field can be entrepreneur, it can be business, it can be some other type of specialty, but really saying that the person has risen to the top of their field, and they've demonstrated that by meeting at least 3 of 8 defined criteria. Now, the 8 defined criteria, and we're not going to spend a lot of time going through each of them. And as I said, there's separate webinars where we go through these in a lot more detail. But for example, one of the criteria is evidence that you've been asked to judge the work of others, either individually or on a panel. So that, when you've been asked to judge the work of others, the US government is saying that, oh, wow, there must be something about this person that that people feel that they really know what they're doing, so they are judging the work of others. So It could be that you, that you sit on some board of an incubator, and the incubator is deciding which businesses get funding, and you are deciding between the different applicants and judging. It could be that you sit on a journal and you're deciding which publications are going to be published. So that, that could meet that criteria. Another one is evidence that you have, kind of high salary in the past. So that's, you'd look at your profession and you'd look at what people earn in your particular profession. And the government says if you earn a lot of money, then that must mean that people think that you are very valuable. Another one is that you've had a lead or critical role in a distinguished organization. And another one is that you have kind of original scientific or scholarly contribution to your particular field. So if you meet 3 of those criteria, you might be eligible to move to a green card under this category. Now, admittedly, this particular category is not one that is as common as some of the others in terms of moving from an E-2 visa to a green card, but we do see it. We do see it as well. And as I said, I think a couple of people have asked about the presentation. As I said close to the beginning, is that you will get a copy of the presentation and the actual PowerPoint presentation after the webinar, but we're not sharing it during the webinar. So then the other kind of, but I'm going over everything that's in the actual presentation. So the other thing that is important about this particular petition is that you are able to self-petition for this particular petition. So what that means is you don't need a sponsor. You don't need someone to sponsor you. So, that is very, very important for some people, because if you don't have a job offer, you can still perhaps get a green card with this particular. And in particular, if you're on an E-2, it means that you're not working for another company, you're working for your own company. So the need to self-petition becomes imperative. So that's, that's good in terms of moving from an E-2. And then, as I said, it's a 2-step process where the first is that you're proving that you meet the criteria, so that you meet 3 of the 8 listed criteria that the government gives you. And the second, that you're going through the I-485 or consular processing process. But as I said, this particular area is not one that we see nearly as much in terms of in terms of an area where people move from E-2 visa to to green card, but it is one that we have seen and have done in the past. So the second area that we're going to talk about is one that we have a number of clients where we moved them from E-2 to this green card, and we have a number of clients in the pipeline where we are working on moving them from E-2 to a green card. And this one relates to EB2 national interest waiver. And so this one, just to give a bit of background on this one, is that the government in late in 2016 decided on a case. So the case was denied by USCIS initially. It went for appeal. The appeals board looked at it and said, yeah, we think this is approvable and it should be approved. And then they came out with a new standard for how this particular green card area should be adjudicated. And the name of the case is Danisar, just for your general interest. And what they said really was that in order to be able to get a green card in this category, you must meet 3 criteria. And the first is that you have to, whatever it is you're coming to the US to do, it has to have substantial merit and national importance, right? So now what that means is it could be that it has to be something the government finds is important, right? So that they have an interest in promoting. So it could be diversity initiatives. It could be hiring US workers. It could be, we did a national interest waiver case where the person was a counterterrorism expert. It could be that they are, aerospace engineer and they're providing innovative technology or ideas for that particular industry. So it can cover a wide range of areas, but the first thing that you're doing is looking at what is the person coming to the US to do? So really independent of the actual individual at that point, but what is the person coming to the US to do? And then once you, would the government find that important, right? And it can be, and one of the interesting things about that case, the case is very specific that it could be that you just plan to do something even in one state or one geographic area, and that could still be something that the government finds it feels is important. So that's definitely something to consider. The second prong or second requirement in this area is that the entrepreneur has to be well positioned to advance the endeavor. And this one sounds easy, but unfortunately can be very difficult to prove. Now, the reason is some of the more obvious things would be that the individual has particular expertise, particular education, particular work experience, et cetera. And those ones are quite straightforward to prove. But for this one, the government wants to see that the endeavor is, either moved along to a point that looks like the individual is going to be able to succeed, or at least has a track record. So one of the big things that impact whether a government will approve under this particular criteria is, has the person successfully done something like this in the past? They may also look at, does the person have sufficient investment capital to move this, particular thing forward? So really, they want to make sure that it's not just an idea, but that it's an idea, not just an idea, that it's an idea that the person is going to be well positioned to advance. And that's the second prong. And then really, I think that this prong, the first prong, is a little easier to shape because it can really be anything. You can describe it such that it is in the national interest. However, the second prong is getting at, is the individual positioned to advance what they say the endeavor is, right? So if the endeavor is a grand endeavor, then which it should be, or should be, to be able to get the government to agree that the first prong has been met, then is the individual well positioned to advance that endeavor, not any endeavor, but to advance that endeavor. And then the final prong has to do with looking at whether or not it's a balancing test, and really looking at whether or not the government should waive the labor certification process, right? So, and what we do here is we include a lot of the criteria from prong 1 and prong 2, but then we also include a number of pieces of information related to sometimes that's showing that the individual is exceptional. It's really saying that, well, the labor certification should be waived because this individual has done X, Y, and Z, and this X, Y, and Z is important in other criteria, other petitions like extraordinary ability, et cetera, and that we feel that that's important here. So those are the three Danisar prongs. And as I said, it's the Danisar case has made this particular green card one that is definitely, easier to achieve than in the past, because the legal standard before was quite difficult. As I said, it's one that we are using on a very, very regular basis. We have a number of different EB2 cases, either that have been worked on and approved, or EB2 cases that are pending as well. So really a really great option for a green card to the extent that you have a viable case. The other thing to kind of consider with EB2, though, is that there is kind of a threshold requirement related to EB2 that you have to look at even before you move to Danisar. And that is that the individual has to have, and this is for EB2, because EB2 is broken out into two kind of areas. So one area is that it's EB2 national interest waiver, but then the other area is EB2 related to the individual or a company is sponsoring the individual for a green card. But whether it's EB2 national interest waiver or EB2 company sponsoring you for a green card, you are required to meet a threshold issue, and that is that the individual has an advanced degree, so that's either a master's degree or higher. So for example, if the person was starting their own business, then they might, someone was on an E2 and moving to EB2, then they would be, probably have their own business. and let's say they had an MBA, then we could stop there because they have a master's degree, and that we would stop there. But if they didn't have that, we might look at, do they have a bachelor's degree plus 5 years experience, progressive experience, or if they don't have either of those, let's say they only have a high school degree, then we would look at the exceptional ability criteria. And there are 7 criteria that we look at there, and the applicant would have to meet 3 of them. But often when we do these cases, we're able to stop at either advanced degree or bachelor's plus 5, and say that the person qualifies for the threshold considerations under either one of those 2. And when we look at this for people that are moving from E2 to EB2, then a lot of the time, as I said, there are people who have their own businesses already. So a lot of the time, their argument for the national interest is job creation, right? So economic impact or benefit to a particular community or the nation as a whole. And, and we would, if the business has been operating for a while, we would show an updated business plan. We would show financials related to the company's past performance, that they've already hired employees, that what their plan is to hire more employees. And then also, if there is something, like if the company is just making widgets, that's fine, because you can qualify under this category with just economic impact as your national interest. However, often we like to include more aspects. So let's say the company is not just creating widgets, but they're creating something where we can argue that what they're creating or with the service that they're providing is also in the national interest. Then we will focus on both arguments to advance, advance our argument in petitions. So they can be really, fascinating petitions that really rely on a significant amount of strategy, but it does make the petitions very interesting, and opens it up to really creative ideas that go into the petitions. The next way that people move from E2 to a green card is by being sponsored by a company. So now keep in mind, though, that it is not possible for your E2 company to sponsor you or your family members for a green card. So that's not what I'm talking about. But what we do have is that when you get an E2 visa, the individual comes and can only work for their company. However, their spouse is entitled to work for the company or any other company. So often the spouse will get a job at another company. So he or she will work at, another company as an employee, and then that company will sponsor the spouse for a green card. And when that happens, then the whole family gets to join in that process, the E2 visa holder, in addition to any children under 21. So that is, that's another way that, a lot of our E2 clients move to a green card, is their spouse gets sponsored by another company, because keep in mind, the spouse can work from the day they enter the US on an E2. They don't even have to apply for work authorization anymore. They can apply, they just get work authorization incident to their status. And so they can start working, find a job anywhere they want, and then, they can be sponsored for a green card. And then the process again for that is the same. I-140 is filed, and I-485 if they're in the United States, and then consular processing. And keep in mind, for the EB2 perm, so the EB2 when a company is sponsoring you for green card, that's the same EB2 that we're looking at for a national interest waiver, except, as I mentioned, they're broken down into 2 categories. But when you're doing an EB2 for a perm, the individual still has to meet the threshold requirements that we talked about earlier, where the individual has to have either an advanced degree or exceptional ability. So that's something to keep in mind. It doesn't just go away because it's a company sponsoring you for a green card. But however, if they don't meet the EB2 criteria, the threshold criteria, the company could still sponsor them for a green card, but just under the EB3 category. So EB3 sometimes isn't as current as EB2 is, and then it has some other drawbacks with respect to advancing of the perm. And we do have separate webinars on, as I said, on all of these topics, but in particular, there's a webinar on moving from this particular type of employment-based green card where a company sponsors you. And we go into a fair amount of detail on that particular process, long and drawn out process. So the next way that individuals move from E2 to a green card, and again, we have a number of different clients that we've done this for, is E2 to EB5. So what this is EB5 and E2 are, brothers or sisters or related in some way, in that E2 is the non-immigrant or temporary visa, whereas EB-5 is the green card. Now, EB-5 is just more difficult and it's more specific. So unlike E2, EB-5 has a very specific investment amount and has a very specific employee requirement. So but what you can do is EB-5, you can utilize with EB-5 is you can utilize often you can utilize some of what you have done with your E2. So if someone, for example, started an E2 business 10 years ago, and they invested $300,000 in that business, they would still likely be able to use that $300,000 to count towards the EB-5 investment amount. So let's talk about what is required for EB-5. So for EB-5, you're required to invest $800,000 or $1,050,000 in a new commercial enterprise. Now, new commercial enterprise doesn't mean new as in, that new. It's like a commercial enterprise or an enterprise formed after 1990. The exact date escapes me, but it's an enterprise that was formed quite some time ago. So, we've had clients. We have this one client who we did an E2 to EB-5, and they had a farm, and they had, the farm maybe, let's say, started in 1995 or something like that. And they had invested over the years more and more money, and they now have their green card. I think their actual card was produced just the other day. So investing $800,000 or $1,050,000, in terms of the difference, why it's lower, one's lower and one's higher, is that if you are investing in what's called a targeted employment area, so an area where the unemployment rate is 1.5 times the national average or higher, or a rural area is defined by the local government, so low population, then you can invest the lower amount of $800,000, and that amounts can be scaled to inflation over time. So, in terms of another kind of, we see one difference with E2 is that the amount, so E2, there's no specific investment amount here, there is. The amount can be invested in over time, but also EB-5 has stricter rules with respect to what can be included in that 800,000. So you can't use the money that you spend on certain things like administrative fees, like lawyer fees and things like that. That can't be included in the investment amount. The other thing that to keep in mind when you do have E2, we have sometimes people on E2 and their business starts to make a lot of money. So the business makes, a few $1 million, and then they spend that $1 million in their business, and that doesn't count as investment. Investment has to be money that is, came from outside of the business. Your own personal funds that are invested in the business for EB-5 requires that. E2, there are lots of different arrangements you can do. You can invest through companies and do different things like that. But EB-5, you have to have possession and control of the funds, and they have to be outside the business and then invest in the EB-5 enterprise. The other thing is that the EB-5 has a very, very, very difficult source of funds requirement. So E2 also has a source of funds requirement. However, the EB-5 really takes that to another level. So, we say to people that your source of funds requirement, it would be something like, if you did something for E2, then maybe you multiply it by 100, and then you might be somewhere close for what you'll have to do for EB-5. So it is quite an onerous requirement. And EB-5 also requires that the investment is equity. So it doesn't require that, sometimes we have people that move to EB-5 because they, can no longer maintain 50% of the company. EB-5 doesn't require that. There's no nationality requirement. And also an individual can own a very, very small percentage of the company and still qualify for EB-5. So definitely it's a big way we work with clients to move them to a green card. The other big difference between E2 and EB-5 is that EB-5 does require that you create 10 full-time jobs, and those jobs are quite specific. A, that they're full-time, and B, that they're jobs for US citizens and green card holders. So that's something very, very important as you're hiring the people, to make sure that you are checking to make sure they have legitimate ability to work in the US, because the government certainly will. Before they kind of give you the green card or remove the conditions on the green card. This petition often requires a very, very detailed business plan, often a little bit more detailed than an E2 business plan. And then the final thing is the money that you invest here has to link to job creation. So we have, in some situations where, let's say that you have an individual who purchased a company, let's say they purchased a restaurant. For E2, that would be completely fine. Let's say they spent $300,000 and they gave the seller $300,000. E-2, that would be completely fine. However, for EB-5, that wouldn't work, unfortunately, because the money went to the seller. It didn't have anything to do with job creation. For EB-5, for that to work, the money would have to actually be invested in the particular business. So that's something to keep in mind. Then the way this petition is filed, again, is a two-step process. Instead of an I-140 or an I-130, I-130 is family-based, I-140 is employment-based. This one, you file an I-526 petition, and that petition is really saying you've met all these requirements. You've invested the $800,000 or $1,050,000, and you have the ability to create 10 full-time jobs, and the money's at risk and things like that. So then, one great thing change on March 11th with this particular program is that you now are allowed to file the I-485 concurrently if you're in the United States. So an individual can file an I-485 and also employment authorization and travel authorization. And that's especially important with this category because EB-5 petitions take years to be approved. So, the current wait time for EB-5 petitions is probably in the 4-year mark to be approved. So now if someone's in the US, they can file documents so that they're able to live and work in the US until their petition has been approved. So some other green card categories that are, less common, but, definitely worth noting that we have individuals move from E-2. We have some E-2 clients. It seems every year we get an E-2 client that wins the diversity lottery. So that's one way we move them to a green card. There are also some humanitarian-based green cards where, you assist the police with a crime and things like that. But there definitely are some, humanitarian-based green cards that are, worth looking at to the extent that they're relevant for your particular situation. And then finally, just some timing considerations. As I mentioned, the EB-5 petition is quite long dated, but I think that it's always very important to, when you're moving from an E-2 visa to a green card is to plan it out well. Like, good time to start the process for moving is after your E-2 visa has been renewed so that you have lots of time to plan out getting the green card. Because once you apply for the green card, it may be more difficult to get the green card, to get the E-2 visa renewed. So better to, like, if let's say you're starting the green card process, better before you actually submit the paperwork for the green card process that you do the E-2 visa approval, and then, you have a bit more time, more breathing room to kind of work everything out. Definitely you have to manage that all with, with travel and your ability to come and go as you're going through that process, but definitely something to look at. We do also have a lot of people, not a lot, but some people who do what are, I call like parallel green card strategies. So we have someone that we have an approval for an EB-5 petition, but that person as well is probably eligible for a national interest waiver. So we're working on that with the individual as well to get the green card that way. And the reason is EB-5. When you get the green card for the EB-5, you initially get a 2-year green card, and then you have to go back and file yet another petition 2 years after that, proving that you actually did hire the US workers. And then after that, they remove the conditions on your green card. So it is quite a long, drawn-out process, whereas if you obtain the national interest waiver, you'd be good to go as soon as you got the approval. You get the green card, and then it would be a 10-year green card right away. So that's appealing to this particular client. Perfect. So that is everything that we're going to cover today. I'm looking in the Q&A and the chat, and I don't see any questions. I know it's a lot of material, and it's, definitely these areas are the more complicated employment-based areas in the immigration world. But definitely, if you do have follow-up questions, you can set up, one of the things that we're going to send you is a link where you can set up a consultation. You can set it up with myself or any lawyer at the firm and go over, any of these particular topics in more detail. As I said, also, we're going to send you a copy of the PowerPoint presentation and the video. And we do encourage you to sign up for our YouTube channel, because we have regular videos that are, we do at least one a day, and moving to sometimes even more than that. And they're always on, current immigration topics and or webinars on current immigration topics that are quite interesting. And so again, my name is Ian Scott. I'm from Scott Legal, full service immigration business law firm, and we look forward to working with you in the future. Oh, I see one question that may have come in. Okay, so yeah, it's just someone's asking if chat is disabled. As it's mentioned at the beginning, so some people may have joined later, is that we don't kind of, there's no ability to kind of ask questions out loud, but the questions, you would add them to the chat function or the Q&A function, and then we would be able to answer them that way. So I do see a question here. If my E2 business owns equity in another business, does that qualify for an EB5 investment? So no. So the EB5 has to be, so let me just tell you what does qualify, because I'm not 100% sure on the question, but the investment has to be from your own personal funds. So E2 does allow you to invest through another business. EB5 does not. So for EB5, you have to, so just give you a crazy example. USCIS used to deny petitions for EB5 where the applicant would get a loan or a gift from their parents. And then the parents would, instead of giving the money to the child, they would send the money directly to a regional center. So regional centers, so basically they put the money in the business instead of giving it first to the child. And then the USCIS would deny the petition, saying that the child never had possession and control of the money. So we're denying, even though it was as clear as day that the parents were gifting the money, just the parents put the money directly into the business rather than sending it to the child first. So they're very, very particular about how the flow. So if you're thinking of EB5, it is quite a process and quite a discussion around around exactly how to move forward with the flow of funds and where funds can come from and where they can't. Perfect. Okay, excellent. So thank you very much again, and we look forward to working with you in the future. Bye-bye.